So let's give Mr. Maye and Mr. Mitchell a big round of applause.
Thank you. Thank you, everyone. I want to first make sure that everyone can hear us well. So hello and greetings to everyone in Greenville, South Carolina. Okay, well, as it was said, I am Jeffrey Maye, principal with International Development and Planning, and we have with us also Mr. Michael D. Mitchell. And if it's okay, we do have a brief PowerPoint presentation that we want to share with you, but we also will be talking about other things that go beyond the scope of what we actually have here. So first, I want to do a sound check again to make sure, can everyone hear my voice fine? All right, and you all can see my PowerPoint presentation? Outstanding. So again, greetings on behalf of the Greenville Human Relations Commission. I want to thank you all for actually participating in this Fair Housing Conference. Happy Fair Housing Month. We do apologize that we can't be there physically with you, but we are very fortunate that we can actually be a part of this wonderful conference virtually. So what we're going to be doing with you all in this session is actually, it's 22 fair housing cases and complaints that have actually been filed or actually were resolved, let me correct myself, in 2022. And what we're going to do is, there were hundreds of cases that have been filed, but we want to just talk about a few of them that we think are really important and that really kind of point out some really important things. And most importantly, in a number of them, talk about the outcomes. Some of them have dollar outcomes that have been published in terms of settlement amounts, but others have other features and relief that are in it as well. However, before we actually move on much further, I do want to just say a couple of things. Greetings to the Greenville, South Carolina Human Relations staff. I haven't seen you all in quite some time. It's wonderful to be a part of this, and your commissioners. I want to thank, first and foremost, I want to thank the commissioners. However, I also want to thank Commissioner, my frat brother, Commissioner Martin. I know he told me not to refer to him as such, but I want to thank Commissioner Martin Watson for inviting us and allowing us to be part of this. So I want to thank you all for that. Just a little bit more about us to kind of give you all the context of why we're here. We are members of the fair housing community. We've both been doing fair housing work for over 20 years. I've been doing fair housing enforcement work for over 20 years. Michael D. Mitchell has been doing it for over 25 years. And before we started training and actually providing technical assistance and working at International Development and Planning as consultants, which we are currently doing, and we serve as consultants, to give clarity about that. We serve as consultants for HUD's Office of Equal Opportunity. That's the United States Department of Housing and Urban Development out of headquarters. So we work with the Fair Housing Office. We also work with Community Planning and Development, Public and Indian Housing as well. We provide technical assistance to fair housing groups, those who investigate fair housing, both on the government side at the local, county, or state level, as what those are called FAPs, Fair Housing Assistance Programs, and those that are just doing Human Rights and Human Relations Commission work in general, as well as we train the Fair Housing Initiative programs. These are not-for-profit agencies that actually conduct investigations and address and assist the general public in investigating and addressing their fair housing rights underneath their respective organizations. So we train those organizations all across the country. We also train their counterparts, who are the entities that dole out the Community Development Block Grant Funds, CDBG more commonly referred to. So we train both those groups, but we also provide them technical assistance on behalf of HUD's Office of Equal Opportunity and HUD's Community Plan Development all across the country. However, before we started doing this work, we were investigating principally all those different entities that must comply with the Fair Housing Act, but we really specialized in investigating banks. So we've investigated real estate companies, large rental management companies, homeowners insurance providers, national homeowners insurance providers, as well as lenders across the country. Doing that work, we obviously have gained and amassed a lot of experience, but we want to share that, and we feel it's important to give people that background. So when we're speaking about the cases or talking, providing technical assistance or training in general, we're not speaking from a trained perspective, but we are individuals that have investigated when we're investigating banks. You had to have assets of 100 billion. I did say billion with a B, $100 billion in assets for us to investigate you. So we really are well steeped in conducting investigations all across the country. And we've also had the great pleasure of being involved with the fair housing infrastructure of the state throughout the state of South Carolina. So that being said, sorry to give you all such a background, but I want to make sure we're doing that so people understood who you're talking to. Lastly, we are faculty for the National Fair Housing Training Academy. So that's a group that also trains these groups all across the country. Aside from us being the lead faculty, we are the lead curriculum developers as well. So what's important about us is that we're here to serve you, and let's actually get into our PowerPoint presentation, what we're going to be discussing. This is Mr. Michael D. Mitchell. I also want to say a few things. Keep it moving. I'll keep it moving. He's a great, extraordinary fair housing enforcement mind. Just know that. Just know that. Licensed in the state of California. So with that, so there are a number of cases that are important, and there's been a lot of activity. So we're going to try to move through as much as possible, these cases that are here that you see in front of you, but we also are going to be moving through other cases that we think are important as well. And the way that we want you to think about this is we're first going to be showcasing HUD cases. These are cases that either FAPS or Human Relations Commissions or FIPS have investigated, and the government got involved at some point in the course of the investigation. And there's a charge in the case, which is important, a charge in the case, and then there's also a resolution of the case. So we want to just kind of talk about them quickly, but there are also cases that the Department of Justice has done as well. The cases that private groups have brought as well. So we want to talk principally about these HUD cases so people can have an understanding that when you file a fair housing case, if you violate the fair housing law or the South Carolina fair housing equivalent law, that there are ramifications. And so those persons who are assisting or those complainants, those persons who believe their rights have been violated, that there can be something clearly can be done and that there can be a resolution. And so here are just a few of those cases. So first one we want to just remark about, and what I also want to do is as we move through them, I'm going to share my screen as we're doing right now, but I'm also going to put on the screen and then put into the chat where you can actually get more information about it. So this first case, actually, HUD charges owner of San Francisco Bay Area apartment building with discriminating against families with minor children. And so the part that's important about this is that you can see that California actually, there are a number of cases, and the second case that we're going to talk about, both unfortunately involve families with children. So by showing you a little bit about these cases, I don't want you to think like, okay, families with children, that's the new hot issue. No, unfortunately, we're seeing that discrimination on the basis of disability is still the leading basis in which complaints are being filed. If you want more information about that, you can actually take a look at the HUD FHEO, Office of Fair Housing and Equal Opportunity, annual report. And for at least the past 10 years, you will see that the leading basis for complaints being filed were on the basis of disability. The leading prohibited act has been different terms and conditions. And that's because of we've seen a lot of, all across the country in rural, suburban, and urban areas, assistance animal cases, that's service animals or emotional support animals, really, that's the largest number of complaints that are filed. However, we do want to kind of showcase some other cases that are really important. So let me first just kind of share my screen quickly. And I want to first go to the case that we were talking about here. Let me actually.
And if I put the links to these in the chat, are people going to be able to see that? Okay.
All right. So this case here, just very quickly, and it says that this is a case that it was brought against these two owners in California. They unfortunately had practices that discriminated on the basis of families or children that's under the age of 18. Their policies unfortunately made housing unavailable to families with children, which clearly, when we're speaking about underneath the Federal Fair Housing Act, as well as the South Carolina Fair Housing Act, there are at minimum seven federally protected classes, which are race, color, religion, national origin, familial status, disability, and gender. In terms of this, what I thought that was really important about this, and this is why we want to just quickly showcase this, is that it said, I want to just pull point here. Principal Deputy Assistant Secretary Demetria McCain, who is the highest ranking and appointed besides Secretary Fudge. She's underneath Secretary Fudge. She was the person that's quoted in this particular case. And it says HUD charges discrimination alleged that when the couple first rented a one-bedroom apartment, they were pregnant with their first child. They later had a second child. The charge asserts that even before the couple moved into the apartment, Trinell expressed displeasure that a child would be living in a unit and suggested that the couple rent a larger, more expensive unit instead. From then on, she made repeated efforts to convince the couple to move to a larger unit, although the couple made it clear that they couldn't afford it. After learning the couple was expecting a second child, Trinell allegedly increased their efforts, repeatedly telling the couple that the children would cause damage to the apartment, feeling harassed and at risk of imminent eviction. The family moved out of the apartment. So just a little, let me just kind of go to the gallery right now so you all can see us a bit more in terms of this. So that case there, just to give a context, even though the apartment was large enough, it was about a 600 square foot apartment, and under the local housing and building codes, it was enough to accommodate it was found up to 5 people could have lived in that apartment. The housing provider was really pushing them to actually get another unit. Now, I want you to understand that push to get this couple to get another unit was in essence making that apartment complex and the units in that apartment complex unavailable to that couple, because the one bedroom that they were renting was renting at $1,800. The 2 bedrooms were renting at $3,000. The 3 bedrooms were renting at $4,000. And the couples, the couple being a young family with 2 new children, with 2 young children, they weren't in a position that the mother was in a position to work. The father had just taken a job as a firefighter, if I'm not mistaken. He was still in his probationary period. So even though he was where they were located was very convenient for them to live because it was close to his work, they then had to move out of San Francisco area to Sacramento, which then in turn created a greater hardship that this firefighting professional had to drive to work a very long distance in order to be able to provide a service which is essential to all of us. So you can kind of see that from a damages perspective that's a really outrageous and kind of egregious example. But we want to showcase that one because just showing you that this case was not only dealing with familiar status, but also dealing with occupancy standards that were unfortunately trying to be used in a discriminatory fashion. So that was something that's just information about that case. I next want to move on to the HUD judge orders Plano, Texas landlords to pay $140,649 in a race discrimination case. I'm going to just quickly share my screen on that one as well. And sorry of that. And here I just want to point out here in this case here, it said the ALJ finds that the agent Dang Tran and property owner Hang Nguyen and HQD Enterprise refused because of statement inventory advertisement on Craigslist and reached against the woman because of the complaint with HUD. And this is something, unfortunately, this use of the retaliation claim or Section 18 of the Act is something that the Department of Justice has been advancing more than it has been used previously. I do want to just kind of highlight quickly some information here, and then I'm going to move on to the next case. It says on June 25th, 2019, HUD filed a charge of discrimination on the woman's behalf, alleging that Nguyen and HQD Enterprises LLC violated the Fair Housing Act because of race. And in 2019, after HUD prevailed partial summary judgment, the landlord retaliated, that's a woman, by filing and settled for $149,000, $649.36. Again, it breaks out how the compensation happens in that case. Let me move on to the next one, which is, share my screen quickly, and then I'm going to pass the floor. This next one actually is a case of $3 million settled by the state of California.
Jeffrey, we lost connection for a bit. Do you mind going back to the previous one just to
Of course.
hit that last point about the amount and?
Yes, please. I can do that. Let me just make sure. Can everyone see my screen? Okay. And it was right here.
Below it. So the amount was $140,649. And then it breaks down compensatory damages, civil penalties, and attorney's fees.
Yeah.
But the next case Jeffrey's going to talk about is far more money than that.
Yeah. And just let me know when you all are ready for me to move. All right. Thank you so much. So next, the next case that we want to just discuss briefly, and then I want to give the floor to Michael. I almost feel like just kind of talking a little bit about it, because I really also want to talk about the housing discrimination cases that also involve appraisal discrimination as well. But I do want to showcase and give its due justice and time to this particular case here, which is, let me just share this. It says, HUD Fair Housing Partners reached a $3 million settlement with California housing provider, resolving allegation of housing discrimination against families with children. Now, the reason that this case is important is because, yeah, there we are. Hopefully everyone can see my screen. Excellent. The reason that this was important is because you don't have a live bona fide in the sense that what you may traditionally see these types of cases. This case, though it involves bona fide and a relief fund of sorts to kind of identify those aggrieved persons, this case was initiated by the state of California California Civil Rights Department, as you're going to see here, as you'll see right here. And the part that I think that's important about this case that we want to share is that what I want to do is quickly share with you some of the things that actually came out of that. So this case here involved the state of California Civil Rights Division, which previously was the Department of Fair Housing, Equal Opportunity, Department of Fair Employment and Housing, let me correct myself, Department of Fair Employment and Housing. They brought this case as a commission or an agency initiated case. They worked and investigated this case over a number of years because of the size of the provider. And I'll start, let me just go up to the top of this so you can let me share my screen. New share, there we are. And so in this particular case here, the defendant, Vasano, this was the name of the entity that the claim was brought against. But it says, and I just wanted to point out, this is, oh shoot, it's not doing as wonderful as I had in my word too. Oh, there it is. It says, defendant Vasano is a California corporation which provides property management services to approximately 48 apartment complexes in San Francisco Bay Area, including Alameda County. At various times, the company has been property management and managing certain properties of property owned. There's such properties that they own, as well as the properties of managing the properties that are owned by other persons. The part that's important here is that here's some of the things that unfortunately were found to be in violation of the California substantial equivalence of the Fair Housing Act, as well as the Federal Fair Housing Act. And it says here that the California Civil Rights Division complaint alleges that the defendant and through defendant Vasano implemented two facially discriminatory rules at their respective properties in violation of the FEHA, which is the Fair Employment and Housing Act, and UNRRA Act, and also the Federal Fair Housing Act. They require parents to closely supervise children under the age of 14 in all common areas and prohibited outdoor play activity in all common areas, such as, among other things, bike riding, skateboarding, rollerblading, and ball playing. So there's also a fair housing group that was involved in that case. It was ultimately settled for $3 million. But what's important about it is that this was a long investigation that took place over years that the agency itself brought, and it brought it not only to address the discrimination of the different properties that were being managed by the management company, but it also, in its relief, sought to actually set up a fund to actually address the discrimination of others that had not been identified, that they had to go out and in the future identify persons that may have actually tried to apply for apartments there or that had previously lived there that was subject to this discrimination that took place. So again, on that one settled for $3 million. We can talk more about it, but I do want to now give the floor to Michael D. Mitchell so that he can actually share a few other cases that are beyond, some of them are her cases, but beyond the scope of that. But also I think one of those cases will be the appraisal discrimination case, which we are aware of, that one of the previous speakers also spoke about discrimination in the appraisal process. So with that, let me give the floor to Michael D. Mitchell.
Thank you, Jeffrey. So there are a number of fair housing cases that I just wanted to mention. I put a lot of resources into the chat. One of the first resources I put in there was about the South Carolina Human Affairs Commission. And it has a list of the cases that have been settled by them. And because any case that is settled in conciliation is a public document, you will see that there are documents related to the settlement of these cases. Now, a lot of them are heavily redacted so that you don't have information about who the complainant was, sometimes even information about who the respondent was, but it does have what the terms of settlement are. In terms of a conciliation agreement, an agency like the South Carolina Human Affairs Commission has to have public interest relief in their conciliations and also relief for the complainants. Oftentimes, these have been reasonable accommodation cases, and so the relief to the complainant is that they get their parking spot or they're allowed to have their emotional support animal. A lot of times the relief in the public interest is that there's training, that there's a policy change, that there's a commitment not to discriminate by the respondent, and sometimes there's some damages, but also there is monitoring that's going to be done by the South Carolina Human Affairs Commission. So you'll see a series of cases there if you go to those links. That second link has all of the conciliation agreements of the last couple of years. Jeffrey talked about the big HUD cases, and he mentioned that California case. California is kind of a leader in some of these fair housing cases, both in terms of cases that come to them and then cases that they file on their own initiative, which they are allowed to do, just as South Carolina Human Affairs Commission can file cases on their own initiative when they think that discrimination is occurring. And we'll talk about the Department of Justice filing those kinds of cases as well, pattern or practice cases. Then there have been a number of cases that have been filed by private fair housing organizations, by the National Fair Housing Alliance, which is a membership organization of a lot of the private fair housing organizations, and they take on some of the big systemic cases. Oftentimes they are represented by Relman and Colfax, who has also filed a number of cases. I'm going to talk a little bit about some of those cases right now. So NAFA filed a case against Fannie Mae, which they settled in 2022. It was a landmark case, settled for $53 million. And it alleged that Fannie Mae was allowing houses in communities of color to fall into disrepair, whereas similarly situated houses in white communities they were taken care of, they maintained them, and they marketed those foreclosed homes and got them back into commerce. And there was a great deal of damage to those communities of color that had the housing fall into disrepair. And that was in 39 different metro areas. And there were 20 fair housing organizations that joined the National Fair Housing Alliance in this suit against Fannie Mae. And again, it was a $53 million settlement. Another major systemic case that they filed was against Redfin, and they settled that in 2022 for $4 million. And Redfin's one of the nation's largest real estate service companies, and they had a minimum housing price policy. So they wouldn't market or sell houses under a certain amount. And oftentimes the value of houses is dictated by the neighborhood in which it's in or the racial composition of that neighborhood. So very similar houses in a white neighborhood, they would market and sell, and very similar houses in a predominantly Black neighborhood, they would not. And so they agreed to change that policy to put $4 million into a fund that will help counter redlining and residential segregation, and will be used for monitoring and compliance programs and home ownership opportunities in the cities that were covered by the lawsuit. There have been some issues that have come up in Florida, issues of standing in some of the fair housing cases that have been brought. And without going into a long explanation of standing, in order for somebody to file a fair housing complaint, they've got to be an aggrieved person who alleges that they were injured by a discriminatory housing policy or practice by the respondent. And organizations, private fair housing organizations, often file these complaints, and they often file it based on testing. And so there's a long-standing understanding that these fair housing organizations have standing to file these complaints, and the testers have standing. But there have been a number of cases in Florida that have been challenging the standing of the organizational standing. And so we're looking to see what happens with that. I think that the Supreme Court may be taking on some of those cases in the very near future. The final kind of cases that I wanted to talk about were those that are filed by the Department of Justice, who has been very busy civil rights cases under this administration. And the Department of Justice can file cases when they believe there's a pattern or practice of discrimination that rises to the level of great public importance. They can file that on their own initiative. And so they've done that in a number of different kinds of cases. They have in conjunction with HUD, a sexual harassment initiative, and they have filed a number of cases against those that are sexually harassing people. They've also filed a number of lending complaints dealing with redlining in communities. And they recently settled a series of those complaints. And I think that was mostly in 2021 and 2022. And there was, I have to get the exact number, but millions of dollars were involved in those redlining cases. They've also dealt with disability cases, design and construction cases. And I believe there were 14 developers that they filed against in New Mexico for failing to design and construct those communities in accordance with the accessibility requirements of the Fair Housing Act. And I know that we are very short on time, so I won't belabor some of these cases, but I will say that the Department of Justice has been very aggressive in filing those pattern and practice cases, also filing those cases that come to them from HUD when there's a cause determination, and they take those cases into federal court. They've also been very aggressive in appraisal cases, which is a major initiative of this administration. And they have filed a number of statements of interest, which allows them to intervene in these cases. They're not the ones that brought the case, but because of the importance of the case, they step in and draft a brief about the importance of and the coverage of these cases under the Fair Housing Act. And so they've done that in a number of different cases. And I think that I've put that into the chat as well. Yes, DOJ appraisal statements of interest. And if you want to read about the provisions of the Fair Housing Act that are violated when appraisal discrimination occurs and the cases and the statute and all of that, this is a great learning tool to read their statement of interest. And with that, I know we wanted to allow some time for questions and answers. So I will turn the floor back over to Jeffrey and for questions and answers.
Yeah, and I think that this session actually ends at 4:15. So we're roughly about, we're roughly about 22 minutes that are left. So Michael, in terms of not 22 minutes, about 27 minutes left. I'm sorry. So in terms of the case, the type of case that you were just talking about, that the federal government, specifically the DOJ, has intervened in, that does give me an opportunity to just talk a little bit about the Tate Austin case, and that you put that one into the chat. Is that right?
No, but I can do that. I can find it, put it in there.
Okay. So what I want to, and the speaker who spoke earlier from HUD, I don't want to go as in depth as that person may have gone, but what I want you to understand and just tell you a little specifics about that case. So this was a African-American couple that was living in Marin County, California. This case is important because it's going to have, we were already seeing a lot of people all across the country, African-American and Hispanic borrowers, bring complaints that are similar to this. There's a lot of discussion about the gap, the wealth gap, the generational wealth gap between protected classes, whites, blacks, African-American, Hispanics, persons who are disabled, other groups as well, not having access to all resources, and that there's a disparity in wealth. But we also it speaks to this issue and the disparity and the gap in home ownership as well, because it's as simple as this. If you are trying to buy a home, or when you're trying to refinance a home, it's necessary that the property, when an appraisal is done, come in at a certain amount. If that dollar amount, whatever the listing price is, or in terms of refinance, whatever the value of the property is, if it doesn't meet what the lenders call your loan to value ratio, or if the loan to value ratio is off, or not off, if it's below a certain amount, it can be 80%, 85%, depending on the lender you're dealing with. Some may be a little bit more generous to a prime market, but if the appraisal does not come at the requisite amount, that means that in the case of a home purchase, the purchase won't be able to move forward as it is. There may have to be some concessions that have to be actually satisfied, which could be the person either getting the borrower to, the borrower having to put more money down, or the seller of the property reducing his, her, or their listing price of the property. In the case of the refinance, if the home does not come in at the requisite amount, the equity that the borrower is trying to access, they can't access it. So literally, it means that if I do not get an appraisal in which the value of the collateral is at a certain amount, the transaction is not gonna be able to move forward. And this is something that we haven't just seen recently. This is something that long ago, when we were, before and after the Fair Housing Act had passed, initially in 1968, this was a form of discrimination that was actually done and undertaken to keep persons of color out of the market. The part that I want to just kind of underscore in this is that this particular case dealing with the Tate Austin that Michael had shared with us, and that he put in the chat, when the Tate Austin, when they initially bought the home in 2016, they bought it knowing that it needed to have a lot of improvements done. Well, they actually, over time, actually made those improvements, and in 2020, made the decision that they were going to try to refinance their homes to pull some of the equity out to finish out to do some things that they wanted to do, but also finish out the improvements that they had done. The first appraisal came back at $995,000. They thought something was strange because of their familiarity with the market. But they decided to do engage in what's called whitewashing, which means, now I don't like that term because if we're speaking about others taking, what it means is people are taking down the pictures, all the items, artifacts that would represent or that would indicate that they are a member of a protected class. In this case, we're talking about being Black or African American. But imagine you having to go down and take all the things that really reflect who you are, reflect who your children or your family's member or your loved ones. Even in the case of the Tate Austins, they had to, Miss Tate Austin said that she had to remove her own hair care products to make sure that the house did not look like she lived there. So when the second appraisal was done, the appraisal value came in once she had removed all the items, came in at $482,500. So it's a difference of almost a difference of about $487,500, almost $500,000 difference. I want you to imagine what you could do with that in terms of, now for some of us, our homes aren't valued at that amount, but to think that that amount of equity was missing or was not accounted for because of that lowball appraisal that was arrived at in the first appraisal, the first discriminatory appraisal. And where I want to kind of just stop with this and then open up the floor, the issue with this case, and the reason that it's so important is that this property, once it's bought, in a refinance, once it's refinanced and it's recorded, it unfortunately becomes a comparable for all those other properties that are in that market, and it has a domino effect. And this is not something exclusive to California. This is something that's happening all across the country in rural, suburban, and urban areas. This low balling of appraisal that's happening both on the purchase and the refinance of persons of color trying to actually either purchase a home or refinance their home. Not only does it impact them as a borrower, but it has a much larger impact on the meso and the macro level, because it impacts all of the other properties that are going to be sold or refinanced in that time period. It has an impact on them at the meso level, but on the macro level, it has this domino effect in which over time, homes that are in African American, Hispanic, and Latinx neighborhoods are going to be persistently undervalued. And in terms of correcting that, that's something that we all need to be thinking about, that I don't think can simply be corrected in the form of redress in the lawsuit. But we just wanted to share that with you all. And I want to be quiet and thank you all again for your time and open the floor if you all have any questions.
Are there any questions for our speakers? Is there questions from the chat? Okay, 2 questions. Well, I have a question while she's going to run those up here. What happens with the 53 million, for example, that was awarded through the National Fair Housing Alliance? What do they do with those dollars once they're awarded?
So that $53 million it resolved the group's claims that Fannie Mae treated homes that were owned in minority and Black communities unfavorably. And the settlement will help to rebuild and strengthen communities of color in 39 metropolitan areas. Let me see if they have any more information about exactly what they're going to do with it. A lot of times it allows for funds to pay down payments and funds for first-time home buyers. Sometimes it allows funds for taking distressed properties and bringing them up to code. I know that in some insurance cases, the insurance companies would say these houses are not insurable, and so monies would be used to make the houses insurable. With foreclosed houses, a lot of times those houses are in distress, and so this would allow funds for either current homeowners or for new homeowners to bring those houses up to not just code, but to make them livable and comfortable. And so the money is usually either divided into pools for those kinds of programs, or they go to the private fair housing organizations that work in those communities to build and develop the communities.
Thank you. We've got
So I
two
think the
questions.
settlement with Redfin that had $4 million involved in it, some of that money was going to monitoring and compliance programs that expand homeownership opportunities. And you can see that oftentimes these are in a lot of different cities and a lot of different states. And so while those numbers are large, once you start dividing the pie, it's not as big as the challenges that it needs to address.
So I actually had one for Dawn, and that one was, whenever you have clients, have you ever had to attend court with them? Yeah. Do you mind telling us a little bit about that? Sorry, it was a complicated question. I smushed it down a little bit.
I enjoy listening to Jeffrey.
And how are you doing, Mr. Dodd?
Yeah, I've never actually had to go to court. Our investigators have had to go to court. Those are our investigators over there. I think Alyssa has had to go to court. I'm not sure about Dolores. You have? Okay, Dolores has had to go to court. I haven't. Greg, you haven't either, have you? But yeah, if we find causes of our case, yes, we have to go to court. And we have to do depositions and all that.
Okay, perfect. And then I had another question for our other two speakers. I was wondering, so what is the average time frame that one of these cases remains open from beginning to end?
As the non-lawyer, I'll give the lawyer answer. Well, it depends. I'm sure everyone expected that. There's two parts of it. So you have when the fair housing groups, the FIPS, or those groups that are qualified fair housing organizations, these are the not-for-profit organizations. They actually may take the case and they can develop the case. And so they do not have to abide by the time frame of investigating the case the way that the FAPs do. But I'll just say this first. There's a statute of limitation that's underneath the Federal Fair Housing Act. The first one is, in order to file an administrative complaint, that would be with the South Carolina Human Relations Commission, where Mr. Don works, or with the Greenville County Human Relations Commission, or a fair housing group taking the complaint and filing it with HUD or one of those administrative agencies. There is a 1-year statute of limitation from the date of the alleged act of discrimination. So the date is 4/20 today, 2023. They would have underneath the Federal Fair Housing Act 1 day before, or 364 days, to file the complaint from the last date or last act of discrimination. So if the discrimination occurred today, they would have until April 19th, 2024 to file the complaint through the administrative process that's either with HUD or with one of those administrative agencies. That being said, the FIP can actually help, or the Qualified Fair Housing Organization or the disability group can actually, or advocacy group can work with a complainant and help them develop that case. So at that case, they're not at that point prosecuting the case, they're assisting the person to develop the case and be able to assert their fair housing rights underneath the local, state, or the Federal Fair Housing Act by filing a complaint in the administrative process. Underneath the Federal Fair Housing Act, in court, there is a 2-year statute of limitation underneath the Federal Fair Housing Act. So that means that from the last day of the act of discrimination, so again, using April 20th of 2023, they would have 2 years. So that means that they have to file the complaint April 19th of 2025 in order to be able to make sure that they were in the statute of limitations. But the part that's important for that time limit is that with the administrative agencies, they have a shorter window. If they are what's called a fair housing assistance program, and they are substantially equivalent, I will defer to Mr. Don to actually share with us what the statute of limitation, I mean, what their statute of limitation is, but they typically are investigating the case for 100 days. Depending upon the complexity of the case, it can take longer than that. There's not a penalty for it going beyond the 100 days for the investigation. However, they do need to communicate to the parties that the investigation is not complete and that it may actually take longer. So the parts that are important, and I'm going to be quiet, the FIP is usually helping them, or a qualified fair housing organization or the advocacy organization is usually working with the person, he, she, they, to develop the case, to file it. So that can actually take some time. Versus once a complaint is filed with an administrative agency like the South Carolina Human Affairs, they have a statute of limitation that I'm now going to defer to Mr. Don Frierson to actually remark about.
Well, actually, can I jump in there for a minute?
Yeah, okay. Go on.
So the administrative agency or HUD is supposed to investigate that case within 100 days. Oftentimes that's not practicable. And as Jeffrey said, they got to notify the parties of why it's not. And but after that, HUD considers that case to be an aged case. And I think after a year, it's an extremely aged case. When Congress amended the Fair Housing Act in 1988, they were looking at what was happening in court. And some of these cases that were going into court were taking 3 years, 5 years. I've been involved in cases that are going through court for 7 years. Protracted litigation takes a long time. And so they didn't want to have a system like that for the administrative process. So they said that, you know, you're supposed to be able to file that complaint within 20 days of it coming into the administrative agency, and then to serve it on the complainants and the respondents within 10 days. And then the respondent has 10 days to answer, and then the administrative agency has 100 days to investigate that. So it's supposed to be an expedited process. Now, because of the complexity and because of the caseload, a lot of times those dates aren't met, but it is supposed to be a much faster process in the administrative process than in the courts.
Yeah, that's correct. In South Carolina, 100 days, to go past 100 days, we have to send out a 100-day letter to notify them that the case is over in 100 days. So basically, you gentlemen are correct.
Thank you. Are there any more questions from the chat? Okay. Well, can we get?
I did want to.
You want to step up to the mic then?
I did want to offer also that going through the administrative process and working with a FIP doesn't cost the complainant or the aggrieved person any money.
Don't necessarily need a lawyer, but if you're going into court, you need a lawyer.
That's right.
We got one question from the audience.
All right. So Mr. Don, he, in one of his cases, had talked about where eviction had been filed on someone. So in the state of South Carolina, once you file an eviction, you process and file an eviction, it stays on their public records. So, right, state of South Carolina does not remove evictions. So in cases where the evictions are wrongfully filed, do they have to remove it? You know, do they have to go back to their courts and appeal and have those evictions removed? Because evictions really sting.
Mm-hmm.
And while oftentimes it is the responsibility of the person, you know, some of the housing clients for non-payment and different reasons, oftentimes it falls on the landlords as well, who they file wrongfully. They don't give them time to, you know, they don't try to work with them.
Or they think they have to file. Even
And they
before
think they have to file and they don't. And so what are we doing in the state of South Carolina to fix that, to rectify that problem?
There's a bill, but maybe Dawn can talk to it.
Just before, because this gonna fall in with it.
Yeah.
Even if it's not a physical eviction, if you do not go with the set out, if you file that first set, which is the notice to show cause,
Right.
it still goes on the person's record
Right.
as an eviction. So maybe that can tie in with the eviction.
Mm-hmm.
I'm gonna look over here for some help because we've actually had this situation happen. Loris, Alyssa, can you address that right quick? I know once an eviction is filed, you are correct, it is very difficult. It's almost impossible. And the reason is, as it was explained to me, and somebody over there could help me out, is because it's a civil action. And it's just difficult to get it off. I mean, it's just almost impossible. Anybody over there? Something like.
Yeah, I was just talking to somebody from South Carolina Appleseed about this at another event. And as of right now, it's my understanding that there's not really a way to completely expunge that and get it taken off of the record. Now, if you have documentation, like we take it to court, then you've got something saying this was judged to be, illegal eviction, that maybe you can supplement when applying for an apartment and explain, the situation. But that would be a question for an attorney, which I am not. So it's my understanding that there's not a way to fully get it off the public at that.
It's difficult. I have not seen it done. The only thing I've seen happen, and this is when I was working on, for a housing authority, they actually gave the lady a letter stating that the eviction was wrong. And she could take that around with her. But I think in order to change that law, it's going to be the legislature that have to change it, because it's just almost next to impossible to get it off. You're right.
There is a right to counsel bill that went forward this session in the State House. It did not cross over into the Senate this year, but it is still part of this continuing session. That's a huge part of the prevention side of this. And that is to make sure that folks have legal representation when they go in front of court proceedings. Yes, it's already there, but sometimes you can get to that, it won't go any further than that. But the problem is, and how it's coded is my understanding, is that even from there on forth, even if the even if the tenant comes out in the right, it is still filed, right? So, and the way that we code things in our system isn't uniform across the state, let alone other states.
So it goes to what we're talking about here.
Yeah,
This is something that keeps people from being housed.
that's right.
And this is one means of landlords weeding out or keeping out certain people.
Mhm.
Because if you have someone who has an eviction 20 years, and depending on if they look like me, unfortunately,
Mhm.
guess what? I don't get housed. I have a hard time finding a place to live. And so at Homes of Hope, the one thing we do, and we have some partnership agents in here that vouch, we do everything we can not to file eviction. If I file eviction on someone, it's because you've given me absolutely no choice.
That's right.
Because I know while you might not be a good housing candidate for us,
Mhm.
I do understand how it will sting you moving forward. And there's also, there's already a huge affordable housing issue here in the upstate.
Mhm.
And so it's just, it bothers me that, it keeps people from being housed. It keeps good people from being
Absolutely.
housed.
Absolutely.
So
Yeah, thank you for bringing that to everybody's attention. Yeah, Mr. Dom.
I needed to know about the eviction court. Where are
Mhm.
we with that? And I understand that Columbia, you guys are starting an eviction court? Is that correct? No? You know where we are here?
I know there's conversations here to start one in the upstate. Yes, absolutely.
One of the things we try to do, Ms. Jenkins is she heads up our intake unit. She was a fantastic investigator before she actually went over to the intake unit. And all investigators, one of the things we try to do is if a person has been given a 30-day notice to vacate and they hadn't left and an eviction hadn't been filed, we'll send a letter to the magistrate to
Mhm.
prevent that from happening. And a lot of times we'll actually show up in magistrate's court to not represent them, but the state of South Carolina, to stop the eviction from taking place until we can find out what's going on. Because you're right, once it's on there, it's just tough.
Are there any more questions from the audience? Oh, there's one from the chat, I believe. Go ahead, Bruce.
Regarding the Tate Austin case, what was the final value of the house, of the home?
1,000,000
Was it the
400
1.4?
$1,482,500.
Okay,
That was the second appraisal.
Yeah.
And but
excellent. No, I'm
Yeah.
glad they got the full value of the house.
yeah, yes, that was indeed. And I also a question about that, and this is something that again, just kind of promoting. We've been trying to get the FAPs, like the South Carolina Human Relations Commission and other FAPs, state FAPs across the country, to establish those relationships with the appraisal licensing and certification boards, because that cost in the Tate Austin case for the second appraisal was absorbed by the Tate Austins. And you can imagine that many people, even though buying a house is an expensive transaction, but you know,
I
it's
think
a
they had to
situation
pay $750 for that second
for
appraisal.
a second appraisal, and you know, that's a cost that has to be absorbed by the borrower in this case, and by most borrowers probably, if they, you know, in the wake that they don't ask for reconsideration and it's not granted by the lending institution. So, you know, so that's something that we've been promoting, because HUD's PAVE initiative, which is a property appraisal valuation equity task force, that was one of their action items of trying to get FAPs and fair housing groups to work with the appraisal licensing and certification boards across the country
Do you have a follow-up
to investigate
question,
these types of
Chris?
complaints.
Yeah, one other final question. We were told this morning that the vast majority of appraisers out there are white males. And one of the things that we need to do, obviously, is increase the pipeline for attracting people of color to become appraisers. I was also wondering, are there any studies out there in terms of the accuracy of appraisers who are people of color, and how are their appraisals for all the folks that they appraise, whether they're white households or people of color households, that kind of thing?
So no, there isn't that's a good question. There isn't a question now. There isn't any research out there that isolates that small, because the percentage is 97% of the appraisers are white males, or white, I should say, not white, are white. And so looking at that subset in that regard of the appraisers being people of color, if there is a difference, what we do have is some wonderful work that's done by Dr. Andre Perry, which might have been talked about earlier, I'm sure, but also Junio Howell. She's done a lot of research examining the appraisal data that Fannie and Freddie have put out. So I would suggest that it makes sense to take a look at that. Dr. Junio Howell and her work has actually arrived at these averages of not based upon who the appraisal is, but based upon the borrower's race and ethnicity, and that unfortunately those disparities persist. And I might offer, if you can imagine, some of the problem, I don't want to go over my time because we, you know, as you can tell, we train on how to investigate these, but think about the domino effect, regardless of the race or ethnicity of the appraiser. What you have in those instances is that those appraisals are not going to be solely just operating out of their biases in terms of properties or the borrowers being of a protected class, and that reflecting unfavorably in the appraisal itself. But also think about that even if you are an appraiser of color, the appraisal is based upon comparables that were out of your control. So even if you're doing this in the most unbiased fashion that you're trying to as possible, you're still dealing with the comparables that have been appraised by others with the same dynamic and phenomena of, unfortunately, the disparities in the valuations of those properties based upon the borrowers and also based upon the location of the subject properties, that the disparities still are going to persist. So that was, if you read Dr. Howell's research, you will find that it gives a lot of clarity, but it also paints a very bleak picture of how we could fix this, or how we can fix it.
Thank you.
Thank you.
You're welcome.
No, we're past time, so do you want to take one more? Or do you want to move on to wrapping up?
So I had one come up in the chat. I thought it was really interesting because it's from a landlord perspective. And it actually points out, as far as going back to evictions, how a lot of assistance programs require an eviction to be present before
Yeah.
they can offer assistance. So a
Absolutely.
lot of landlords will file eviction just so that they can get their tenants assistance, was what they had pointed out. It was more of a comment than it was a question, but more of just an explanation as to why we do see a lot of landlords filing for eviction, even if they do want to keep their tenants around.
Yeah, that's a good point. No, in the past, we used to require in many instances, depending on the assistance, some have moved on and just need some written confirmation from a landlord, but some require that actual filing copy. So thank you so much for this section. Can we give Mr. Frierson, Mr. May, Mr. Mitchell, big round of applause? We'll have Miss Amelia Moore Miss Duckett will come up and wrap us up.